Last week in a hearing in front of Congress in the Appropriations Committee, he was asked about firearms. He said, I'm not an expert in firearms.
Everybody talks about forearm braces. True forearm braces that are not designed and intended to be shouldered.
You were asked a question by a Democrat earlier about statistics on the defensive use of firearms.
Cannot allow New York to become the Wild Wild West.
This finding, the ATF had to delete 252 million records, didn't they?
This bill is unserious and unconstitutional. But we'll get into the unconstitutionality of it.
The Disarm Hate Act was reintroduced into the Senate 2 days ago. It has previously been introduced into both chambers of the Senate and both houses of Congress. Supreme Court ruling on New York's concealed carry law. The U.S. Supreme Court has ruled that New York's law, which has been in place since 1913, is unconstitutional. The ruling, a 6-3 decision with conservative justices in the majority, has led states with similar laws and other laws that may conflict with the court's broader interpretation of Second Amendment rights to race to protect both gun rights and public safety.
Under the Gun Control Act of 1968, the National Firearms Act of 1934. The rule redefined firearms with stabilizing braces as short-barreled rifles so that they could be controlled, not an expert, but still trying to run Americans' lives.
New York State Rifle and Pistol Association versus Bruin is a case focused on New York State's concealed carry permitting law. The state has a law in place that requires residents of the state to secure a permit to carry a gun in public. As part of this process, applicants have to show that they have a proper cause for wanting to carry in public, and this proper cause has to be greater than maybe a member of the general public might need. 2 men applied for concealed carry permits, one for self-defense and the other for a string of robberies in his neighborhood. The Supreme Court struck down New York's law, stating that it violates the 14th and Second Amendments. They specifically stated that the Second Amendment protects the public carry of firearms, which was not the case before today. They also set up a new test for courts to determine whether a law violates the Second Amendment. The new test has to do with history. This all started with District of Columbia versus Heller in 2008, the very first time that the Supreme Court recognized an individual right to own a gun. In that case, no test was set up, so lower courts didn't know how to determine whether a gun law violates the Second Amendment. Eventually, they worked out this 2-part test. Is this something that historically implicates the Second Amendment? And if so, how does it hold up against scrutiny? Is this something that the government has a good rationale for doing, that they have an interest in, and that is tailored to address that interest? Many laws were upheld because the government has a strong interest in reducing violence, and these laws were intended to reduce violence.
There are approximately 40 million firearms with stabilizing braces currently in circulation.
Later during the debate as we offer amendments, but let me talk about the unseriousness of it.
This specific opinion says that courts should look at texts, history, and tradition to determine whether a given law violates the Second Amendment. This standard is common in both state and federal court, but it is still unclear, as history is not necessarily simple. The Second Amendment allows states to regulate guns, but it is not unlimited. States can still require permits for carrying a gun in public, but they cannot have the discretionary piece of the law. This concurring opinion is similar to Justice Scalia's Heller opinion in 2008, which suggests that states and the federal government have the ability to limit the right to carry guns. The dissenting opinion focused more on public health, citing studies in public health scholarship and other social sciences that emphasize the importance of considering the public health impact of guns and gun violence. Justice Alito dismissed public health evidence, stating that if New York's law was great, why did the Buffalo shooting happen? The majority opinion used to be that people who were being considered for the Supreme Court should be restrained in striking down state laws passed democratically to achieve important goals. However, this seems to be an aggressive way of striking down decriminalized laws. Justice Thomas, in the majority opinion, alludes to this, saying that when discussing an individual right as important as the Second Amendment, courts must look to history and tradition rather than defer to legislatures. He also alludes to the idea that courts should defer to legislatures when dealing with an individual right as important as the Second Amendment. The big takeaways from this opinion are more public health oriented. Laws like New York's that require proper cause will no longer exist, and there are public health reasons for not liking those laws. For example, the discretion afforded by law enforcement agencies is not good or bad from a public health perspective. The bigger public health impacts are from the expanded Second Amendment to cover outside the home and the new test for the Second Amendment. There will be many more challenges to gun laws, including gun laws with a strong evidence base, such as permit-to-purchase laws, extreme risk protection order laws, safe storage laws, and minimum age laws. It would not be surprising to see a wave of litigation related to these issues to see if courts are more willing to strike down these laws under this new test. A big question is how courts will apply this text, history, and tradition test to other gun laws. Controversial Massachusetts Bill HD 4420. A background check is necessary for all weapons and feeding devices in the Commonwealth, according to Massachusetts Bill HD 4420, which is likely to pass. The bill also refers to serializing and registering periodicals via a real-time electronic system created and kept up to date by the Department of Criminal Justice Information Services. It is anticipated that this registration procedure will be added to the database for access to all personal belongings.
This bill is unserious and unconstitutional. But we'll get into the unconstitutionality of it.
These individuals could lose the ability to use these tools, and as a result, may not be able to operate.
Because it didn't reduce the number.
Gentlemen, yield for a second. Just for a
I
second.
will here in a little bit. I've got some other points I need to make.
The law leaves no stone untouched and touches on practically every aspect of gun control. One of the original freedom states, which was intended to shield residents from governments that desired total authority and control over their enterprises, has taken a terrible turn. Many states have passed laws that violate the Constitution despite the fact that it was designed to safeguard natural rights in order to do so. Because of how egregiously overbroad the 140-page gun limitation proposal from Massachusetts lawmakers is, local police agencies are flashing lights and wailing sirens. The public was warned by the Ware, Massachusetts Police Department, that HD 4420 is a poor gun control measure in a notice published in the local newspaper. The article claims that this bill targets law-abiding persons as criminals rather than criminals, making it more difficult for law enforcement to deal with actual crime. The State Assembly of Massachusetts has forgotten that more than 200 years ago, in Concord and Lexington, a despotic government attempted to take guns away from its people, sparking the beginning of a revolution.
Today, we are releasing our blueprint to end gun violence.
I was asked by Michael Day's office to send a list of guns that I can currently sell that I wouldn't be able to sell.
In a letter to state lawmakers, Plymouth, Massachusetts Chief Dana A. Flynn encouraged them to drop the bill because it would do more to invade the privacy of law-abiding citizens, vandalize their property, and confiscate it than to protect them. The Ware Police Department considers that dialogue and public participation are essential for creating laws that take into account the varied opinions and worries of people. They exhort Massachusetts residents to actively participate in the democratic process by speaking out and taking the necessary steps to safeguard their rights. The Commonwealth of Massachusetts has a long and proud history of emancipating its citizens from dictators. The National Shooting Sports Foundation and the Ware Police Department in Massachusetts have teamed up to express their vehement opposition to HD 4420, a planned gun control measure that caused significant worry in the neighborhood. One of HD 4420's more divisive provisions is its proposal to give the state attorney general the authority to order state police to seize all weapons manufactured after 1994. Law-abiding gun owners who worried that their legally obtained weapons could be taken away without sufficient due process or rationale are alarmed by this measure. The proposal aims to include firearms with a single aesthetic feature that has no influence on the practical aspects of the weapon in the definition of assault weapons that are prohibited. The guns community has expressed concern about this definition since it may cause many regularly used and legally owned firearms to be labeled as assault weapons, potentially subjecting them to tighter controls. HD 4420's proposal that all legally owned firearms be registered with the state has provoked contentious discussions about privacy invasion and the potential repercussions of establishing a centralized database of gun owners. Critics contend that the misuse or breach of such information poses significant threats to personal safety. The law also recommends that owners of firearms tell the state if they alter their weapons, even if the modification is minimal, like adding optics or a sling to a hunting rifle. Gun owners consider this requirement to be onerous and contend that it adds needless bureaucracy without providing any measurable improvements to public safety. The idea to serialize, register, and require police notification upon loss, theft, or destruction of any mag is a further worrying measure. Advocates for gun rights contend that this degree of control places a heavy burden on law-abiding persons without addressing the underlying causes of gun violence. The bill's attempt to outlaw downloadable gun code from the internet has come under fire as a possible First Amendment infraction. Critics contend that limiting access to information about firearms could stifle investigation, instruction, and innovation in the field of firearms. The bill's poorly written character has alarmed hunters who worry they could not be permitted to hunt on their own property unless it is specifically designated as open to carrying firearms. Additionally, there is no exception for law enforcement officials who are not on duty, making it impossible for them to carry their weapons and properly handle emergencies. Rep. Day persists in pushing the legislation through despite criticism from the public, while Speaker Ron Mariano works to hasten the procedure. The House Speaker Ron Mariano and Chairman Michael Day's support for HD 4420 has the Gun Owners Action League to see it as a historic assault on the whole Second Amendment community. U.S. Supreme Court strikes down New York gun carrying law in landmark ruling. The U.S. Supreme Court has struck down a New York law restricting gun carrying rights in its most important judgment on guns in over a decade. It expands gun rights amid a fierce national debate over the issue. The decision, which jeopardizes similar regulations in states like California and New Jersey, is expected to allow more people to carry guns legally. About a quarter of Americans live in states that could be affected if their own gun restrictions are challenged. The court found that a New York law requiring residents to prove proper cause or a good reason to carry concealed firearms in public violates the U.S. Constitution. Justice Clarence Thomas, writing on behalf of the 6 conservative judges who make up the court's majority, ruled that Americans have the right to carry commonly used firearms in public for personal defense. The 3 liberal justices, Elena Kagan, Sonia Sotomayor, and Stephen Breyer, dissent, meaning they disagreed with the majority opinion. The court's decision clears the way for legal challenges to similar restrictions in Maryland, California, New Jersey, Hawaii, and Massachusetts. It comes amid political divisions over how to address gun violence, which were deepened by high-profile shootings at a primary school in Uvalde, Texas, and a grocery store in Buffalo, New York. The ruling came as new legislation that would tighten access to firearms passed the U.S. Senate. President Joe Biden said he was deeply disappointed by the Supreme Court's decision, which he said contradicts both common sense and the Constitution and should trouble us all. New York City Mayor Eric Adams said he would review other ways to restrict gun access, such as by tightening the application process for buying firearms and looking at bans at certain locations. We cannot allow New York to become the Wild Wild West, he added. The National Rifle Association celebrated the judgment.
We should reinstate the assault weapons ban on high-capacity magazines that we passed in 1994 with bipartisan support.
It would involve the NYPD, every city agency, our courts.
The rights granted by the Second Amendment are not unlimited. Not unlimited.
The gun lobby had helped back plaintiffs in the case. Robert Nash and Brandon Koch, 2 New Yorkers who had applied for a concealed carry permit but were denied them despite having licenses for recreational gun ownership. More than 390 million guns are owned by civilians in the U.S. In 2020 alone, more than 45,000 Americans died from firearms-related injuries, including homicides and suicides. The Supreme Court decision continues a steady pattern of rulings that have expanded gun rights, holding that the right to carry firearms both at home and in public is guaranteed by the Second Amendment of the U.S. Constitution. Even in the shadow of the mass slayings in Uvalde and Buffalo, the 6-justice conservative majority on the Supreme Court stood by a broad interpretation of the Second Amendment to keep and bear arms.
And the House has approved a package of gun measures with a mostly partisan vote.
Who are issued weapons that allow for fully automatic and 3-round bursts. That is not available for purchase in the United States.
The last landmark gun decision issued by the court was in 2010, which upheld individual gun ownership rights within homes on a national basis. As these court precedents pile up, it will be increasingly difficult for future Supreme Court justices to change course and interpret the Constitution as permitting broader gun restrictions. In his dissent, Justice Breyer noted that gun violence has taken a significant number of lives in the U.S. this year. Since the start of this year alone, there have already been 277 reported mass slayings, an average of more than one per day, he said. The Senate, meanwhile, passed the first national gun control bill in nearly 3 decades on Thursday night by 65 to 33. The new law includes measures such as expanding background checks for gun buyers under 21 and offering funding to states that have emergency programs in place to seize guns from people deemed dangerous by a judge. The bill will next have to clear the U.S. House of Representatives before going to President Biden's desk for his signature. Supreme Court to weigh in on domestic violence restraining order and Second Amendment. Advocates for gun rights on both sides of the issue are getting ready for the next conflict over how to interpret the Second Amendment's protections and how it would affect state regulations. This fall, the U.S. Supreme Court will hear arguments to determine whether a federal law passed in 1994 limiting the possession of weapons by those who are actively subject to a domestic violence restraining order is constitutional. It follows the Fifth U.S. Circuit Court of Appeals panel's decision to overturn Texas resident Zaki Rahimi's conviction for having weapons in his possession while under a restraining order. The judges noted the Supreme Court's decision from the previous year and determined that even though Rahimi discharged his firearm in public 5 times in the space of 2 months while under the injunction, it did not undermine his Second Amendment right to bear weapons. The court argued that no such regulations in American history have ever taken firearms away from people who had abused their spouse or partner. According to Robert Spitzer, a political science professor at SUNY Cortland, if you were married to a man and he mistreated you, you have every right to beat your wife, as long as you didn't leave permanent marks 200 years ago. That was the legal requirement. Spitzer, a national authority on gun policy and the author of 5 books on gun control, is dubious that the Supreme Court would entirely overturn the almost 30-year-old federal ban. I think the country could not tolerate such a decision, he continued. I believe it would be difficult for the court to muster 5 votes in favor of that decision. A person found hunting in the wrong area at the wrong time may have their firearms taken away under rules that existed in colonies and U.S. states during the 17th, 18th, and 19th centuries, according to Spitzer. Would that serve as a reliable historical comparison to current domestic violence laws? I would say without a doubt that the answer is yes, he stated. With the current national view of abuse, Spitzer noted that he would be astonished if the court upheld the domestic violence law as being unconstitutional under the Second Amendment. He cited multiple studies associating more violent domestic abuse outcomes to gun ownership. An American Journal of Public Health Control research found that abusers who have access to firearms are 5 times more likely to slay their partners. According to a National Library of Medicine report, 1 in 27 of the 4.5 million American women who are still living today have experienced an intimate partner threatening them with a gun. Rebecca Fisher, executive director of New Yorkers Against Gun Violence, said, "Evidence shows time and time again that when a domestic abuser has access to a gun, the likelihood that their intimate partner will end up being shot and slayed is extremely high. But, the courts are debating whether or not they can actually consider such evidence."
As a leader of New Yorkers Against Gun Violence, I have devoted my career to reducing gun violence in this state.
All right, the Department of Justice plans to fight court rulings calling for a federal gun control, I should say.
And we need Congress. We need federal leadership to stand up and protect us.
A number of anti-violence programs were in operation around the country that were pretty successful at dampening gun violence.
Congress has not enacted federal gun violence prevention reforms.
The state's highest court's judgment, according to supporters like Fisher, who push for tougher gun control legislation in the state, will be crucial in future research on gun regulations around the country. The Supreme Court concluded in New York State Rifle and Pistol Association, Inc. versus Bruin last year that Americans had the right to carry a gun in public for self-defense, overturning a long-standing New York law in the process. Days later, state legislators came back to strengthen New York's red flag laws which enable police to seize a person's firearms if they pose a threat to themselves or others. The state's concealed carry statute was also promptly modified by lawmakers in June of last year, with fewer, more stringent conditions for obtaining a permit. The decision could affect how courts evaluate gun laws and whether or not gun laws nationwide are still regarded as constitutional under the Second Amendment, according to Fisher. The decision will not only have implications for individuals who are threatened by intimate partners and have experienced domestic abuse, she said. The state's strengthened red flag law will undoubtedly face further challenges after the Supreme Court's next ruling on gun rights, which is not anticipated until late spring 2024. The revised concealed carry statute is being challenged in court on the federal level. According to Second Amendment rights activists like Texas Rifle and Pistol Association Executive Director Tom King, the harsher regulation may result in the unlawful seizure of a person's firearms. King stated that, "Your firearms are taken away without ever having gone to a judge. There are no search warrants, no nothing. They break in and seize your weapons. It's the same as if someone had entered and stated, 'We heard you were speeding,' then entered and removed your automobile. Where does it go exactly?" King, who believes the present regulation is overly broad, is optimistic about the Supreme Court's reconsideration of the federal domestic violence statute from 1994. He claims that rather than treating everyone equally, as the federal domestic abuse legislation does, each person's case should be examined separately. "I believe that each situation needs to be examined separately," he stated, "and in my opinion, that is what the Supreme Court is currently doing." The Supreme Court's decision will help clarify last year's gun rights rule and outline the new standards for judges across the country when deciding on legal challenges to current firearm limitations, according to advocates on both sides of the debate. According to courts' inconsistent interpretations of Bruin at the moment, the new decision will bring some clarity to the analysis of gun legislation, Fisher said. If they use a law that is analogous to federal laws and qualifies as historical and fits within the new framework of analysis, that will then give courts, moving forward, more guidance on what kind of historical law should be applied to uphold gun laws in the future. Regardless of the outcome, King is convinced that law-abiding gun owners in the state will be prepared to abide by the court's final ruling. He declared, "They are the highest court in the land." In contrast to Governor Kathy Hochul, who couldn't live with the Bruin ruling, I'm sure gun owners will be able to live with whatever judgment the Supreme Court decides. Before the session ended, lawmakers enacted a number of bills that organizations like New Yorkers Against Gun Violence fought hard for. These included bills to strengthen the state's Victims' Compensation Statute, pass the Grieving Families Act, and raise Medicaid reimbursement for violence prevention initiatives. To determine whether to sign them into law, Hochul has until the end of the year. According to Fisher, she has not stated her opinion on the proposals or if she plans to sign the bills. Disarm Hate Act Overview. The Disarm Hate Act seeks to address a perceived gap in current federal law. It specifically targets individuals who have been convicted of a misdemeanor-level hate crime or received an enhanced sentence for a misdemeanor crime after a judicial finding that they acted with hate or bias motivation. The bill's main provision is to prohibit such individuals from buying or possessing firearms for the remainder of their lives. Supporters of the Disarm Hate Act argue that easy access to firearms poses a significant risk to historically oppressed populations, making hate crimes more likely to result in fatalities. Nick Wilson, the senior director of the Center for American Progress's Gun and Violence Prevention Program, asserts that hate-motivated offenders have been responsible for some of the deadliest mass slayings in American history. Additionally, even when not used in actual violence, firearms are often employed to threaten, intimidate, and demean victims. While proponents of the bill argue that it is a necessary step to prevent hate-motivated violence, critics point out that all gun control measures may infringe upon Second Amendment rights. Some argue that the historical roots of gun control in the U.S. were racially motivated, aimed at preventing black slaves from defending themselves. Therefore, the assertion that firearms target historically marginalized communities is contested.
Why do we have guns? Why do we have the Second Amendment? Is it to hunt? This will not do any good. It will harm Americans, and it undermines our foundational liberties that is crucial.
The Disarm Hate Act has garnered support from a variety of organizations, including the Pennsylvania Center for American Progress, Amnesty International's Anti-Gun Violence Campaign, Giffords, People's Rights Movement, Jewish Women March Worldwide for Their Lives, National Transgender Equality Center, Hotline for Domestic Violence in America, National Partnership to End Domestic Violence, Newtown Action Alliance, Pride Fund, Police Promise of Violence at Sandy Hook, Washington Office on Latin America, Southern Poverty Law Center, and the UMC General Board on Church and Society. The Disarm Hate Act is a piece of legislation introduced to address the issue of individuals convicted of hate crimes having access to firearms. Supporters argue that it is a vital step to prevent hate-motivated violence, while critics raise concerns about potential infringements on Second Amendment rights. The bill has garnered support from various organizations, indicating a broad spectrum of backing for its objectives. However, its passage and implementation remain a subject of debate and contention. That's all for this video, folks. See you next time.